Good evening, everybody. Interfiling is back to the forefront of our discussion. We wanted to talk about
scams.
Yes.
Scams and frauds. That was going to be a fun one. We had all sorts of fun stories for you guys.
And all of a sudden, USCIS releases an update on their website about interfiling, and interfiling now back in the forefront. So we're going to talk interfiling, answer your questions. I'm sure this is back in the forefront. And if we have more time, we'll talk about scam. If not, we'll do it next week.
Yeah.
So don't go away. Okay, interfiling. So USCIS updates their website
Friday.
On Friday.
Yeah.
And basically says, we got a lot of extra adjustment of status space in the EB2 category.
Yeah, this is one of those government things that people might not know about. It's the Friday dump. You know, it's they put out important stuff on a Friday and you know, they cause weekend chaos.
Well, I kind of like it and don't like it. Honestly, I like it because I think there's a little bit of proactiveness. Obviously, I don't like the method of communication, but it's okay.
Yeah.
But it's an improvement that you know, you got somebody that cares and say, hey, listen, you know, we got some space here. Let's see if you guys can take advantage of that. We want to try to move cases along. So interfiling back to the forefront. And before we do that, shall we talk about current events for a minute?
Yeah, let's talk for just real quick because the interfiling is a popular topic. So our favorite current event for a while has been the Build Back Better Act. And is it entirely dead, Sam, or is it, or has its arms and legs been chopped off and it's on life support?
It's like weeds. You cannot get rid of weeds. You know, if you have a lawn and you're trying to get rid of weeds, I don't know what you do, that weeds come back. But this is a good one.
Yeah.
It looks like they're willing to talk again and communicate again.
Yeah.
So that's amazing.
Yeah. So the Build Back Better Act, for anybody who doesn't know, has a great big giant visa recapture provision in it. That, well, the last version we saw did, right? And you know, Joe Manchin says, "I'm willing to come back to the table, but we're going to start fresh." So that brings the question, Sam: is visa recapture still in there?
It's not a.
It's not controversial. Yeah.
It's not something that is a controversial issue. Nobody objected to it the first time around. Manchin didn't say I can't support it because it's there. Obviously, the illegal immigration piece is in trouble, but the legal piece was never an issue of concern, unless we get now opposition showing up out of nowhere saying without the illegal we cannot pass the legal, and anything can happen anymore. I believe everything and don't believe everything when it comes to politics, but it's not dead. For sure. So
we will see. Let's get back to the subject of interfiling. So
all right.
We're talking about this USCIS, this policy alert, this policy blurb on their website.
Yes.
Which for everybody who hasn't seen it, I put actually a link in the description of the video to it. But be careful if you're on a mobile device; it might take you away from us right here. So you may want to look at it later.
Right.
But I will show it on the screen here briefly to show you guys what we're talking about.
Yeah, please do.
There it is. So USCIS added this page here, and at the top here, it speaks of, you know, basically there are tons and tons of green cards available in the EB1 and EB2 categories, right? And if you haven't, well, if you're eligible to get into that category through a transfer underlying basis, you should do it. Not only does it say that, if we scroll down further, there we go, scroll down further, it says, it gives us this fancy new address to send interfilings to. Now, Sam, where did they tell us to send interfilings to previously?
The office having jurisdiction over
the office having the jurisdiction, and that was a challenge in and of itself, figuring out where your case is with USCIS. Yeah. So the way, you know, we've talked about this several times today. Overall, good news, you know, they're trying to get organized and they're saying, we desperately want to get these green cards issued before the end of September 22. That's the very top thing at the top of this page. It says, we are planning to get as many of these green cards issued as we can.
Highlight that part.
Yeah, here we are.
Right there.
There are exceptionally high number of employment-based visas available this fiscal year through September 22nd, 2022, excuse me, through September 2022. They are aware of the issue. This is, you know, last year, you know, everybody started screaming in this, last fiscal year, excuse me, everybody started screaming at them, you know, September, they're going to waste the visas, and they're trying to get ahead of the game, I think.
Well, absolutely. And then on the address issue, again, this is not a policy change. If you scroll down to the address, and it says you must send your request in writing, and it said it should go to this address. So it's not, it must go to this address. If you go there, you may submit this written request. And then it also encourages you to file Supplement J.
Yeah. So that's a thing worth pointing out. Raise your hand if you've read the USCIS Policy Handbook on the subject of transfer of underlying basis.
Well, I'm sure I can raise my hand. I'm looking out there. I see a few guys who raised their hand, but few didn't raise their hand.
Well, it never says anything about filing a Supplement J in a transfer underlying basis request. We have been doing that for some time now, but it's just an interesting wrinkle to this statement.
Yeah, and just to kind of organize people's mind, because people are confused. USCIS chooses now to communicate by way of an update to their website. Now, that is the least informal and legally binding way to communicate. This is not a memorandum opinion. This is not a policy change. This is not in the regulation. This is simply updating their website about what they would like to do. We welcome that, but from a legal perspective, it's the lowest level of communication in terms of binding communication.
I mean,
on
as we get into this further, it's going to be what kind of confidence do we have in this? Does it mean interfiling's an instant success? And
USCIS historically liked interfiling because they don't know how to handle double adjustments.
Yeah.
But we will go down this and break it down. So that's good news.
Yeah.
Shall we go over what is interfiling? Just kind of a refresher.
Yeah, we got the headline out of the way, so let's go into the body of the article here.
Yes.
So, for those who aren't aware, interfiling is a process by which you tell USCIS that you want to change the basis, the underlying I-140, for your adjustment of status. So the scenario that most people are thinking of right now is the following. Back in October 2020, you filed an adjustment of status in the EB3 category based upon an I-140 EB3 downgrade. And now, that category is perhaps looking less attractive because, the priority dates have been kind of stuck for EB3, and EB2 has been going forward like crazy. Essentially, interfiling would be a written request sent to USCIS to say, hey, change the basis from my I-45 from this EB3 I-140 downgrade to my old EB2 case from years ago.
And again, USCIS likes the name transfer of underlying basis, not interfiling. So interfiling is a name that kind of everybody uses. A transfer of underlying basis, if you want to Google that, so you want to put in transfer of underlying basis, although if you do interfiling, I think you'll get a lot.
We'll sometimes call it the tub, which clearly puts a smile on my face because there it is. It's the tub.
We call it a tub because it's a funny name, and I like that name. It's easy to remember.
Wash your case in the tub, you know.
Excellent. So now, so the way it works is you have two I-140s. And you have an adjustment of status that sits on one I-140, and you're asking USCIS to take this I-485 and put it on another I-140.
Yeah.
That's basically what happens. Yeah. Now, what are the requirements?
So you have to establish your continuing eligibility to adjust.
Okay, so let's explain that because we can jump to the next one quickly. What's a continuing eligibility?
Meaning you meet the requirements for adjustment of status.
Yeah. So if the I-140, for example, was withdrawn.
Yeah.
On the first one, before you transferred, that creates a discontinuity.
Yeah.
Non-continuity, I guess, and then you cannot transfer. But if it is denied, revoked. And then you filed request for a transfer, then there is a gap and that will not work. But if, let's assume you requested the transfer and then it was revoked after that, then you're fine because there's no continuity problem.
Yeah, so you've gotten into the second topic. You have to have a continuing pendency of your adjustment of status, meaning, if your adjustment of status has if your adjustment of status has been denied or lost or denied, essentially, you can't revive a dead adjustment of status. Is the a denied case that was denied for, like, say, lack of continuing eligibility cannot be revived through an interfiling or transfer of underlying basis,
Yes.
a TUB.
The third one is eligibility for the new category, obviously. You know, it goes without saying, you
Yeah.
would not be eligible to file an adjustment of status unless you have, let's say, an approved I-140 in the new category, in this case in the EB2 category, which is now the referenced category that USCIS is encouraging people to go to. And obviously it's a zigzag, but obviously that's what they're looking in. So you have to have an approved I-140. If that I-140 is withdrawn or denied, then you cannot. Obviously you can refile a new I-140 if it's been withdrawn, and then you recreate the eligibility. Then you can do a transfer.
Yeah. So the last one is now that immediate visa availability, and that means your I-140 final action priority date must be current.
Yeah. So that's a big one.
Yeah.
Not filing
Not
filing
dates
date.
for filing,
Not
but
dates for
final
fi-
action dates.
Final action date has to be current for you to be able to do an interfiling.
Yes.
And you must meet all the eligibility requirements for a normal adjustment of status. So the question on that is obviously there's a lot of requirements to meet the eligibility requirements. So that's one thing that you have to make sure that you meet the eligibility requirements.
Yes. So, Sam, we have our classic list, which we published a while ago, of our pros and cons of, bear with me as I put it forward. I realized I scrolled forward on our, there we are, on our pros and cons. What's the big benefits of the transfer on an underlying basis? It is cheap because there is no government filing fee for us.
Yep.
It is easy because there's no form. It's really just a letter.
Well, now Supplement J.
Supplement J too, but Supplement J is a relatively easy form. Could say
It
compared to
still meets the easy standard.
Yeah.
It's definitely easy to do. There's no question.
The downsides are no receipt notice, no cash checks. It is
So you don't get a receipt notice.
Yeah.
And now with the Supplement J, you get a receipt notice with the Supplement J, which kind of confirms, if you will,
that we got the package that your interfiling. We got the envelope that your interfiling request was in. Not that we've done anything on your interfiling request.
precisely,
Yeah.
precisely. But no receipt notice on the transfer underlying basis.
Yeah. So no cash checks to confirm.
To track.
Yeah, to
or
track
confirm.
to track it. It is discretionary in nature. They don't have to approve an interfiling request. If they think they're too deep into your process, into the category you're in, they can say no to it. So there's an appeal in that. That could mean they're about ready to approve the case and say your existing category, but
Well, along with the discretionary nature, there is also no communication that they've rejected or they do not want to move forward.
you don't know they've gotten it. You don't know they've approved it. You don't know anything. And
Yes.
we deal with people. We have plenty of people who we know have filed interfiling requests, and they get a little bit frustrated with
Yes.
it because they don't get any government feedback.
Yes. And then there's RFE is common. And then the last one is a big one that people don't understand. They're surprised. Is the 180-day, resets the 180-day for your adjustment status. So after you file your I-485 and 180 days passed, you can change employers and move to a same or similar job classification and move this application with you. And with a transfer of underlying basis, you reset that clock to 0. So you need now, from the date you filed the transfer of underlying basis, you need another 180 days to be able to change employment. And that proved to be very difficult for some people.
Yeah.
When they had an opportunity and they wanted to move, but they filed the interfiling 100 days and they had to wait another 80 days and all kind of complications.
Yeah.
Now, what do you say for people who say, interfiling is the way to go always. It's the only way to do it. Never file an adjustment status because this is for attorneys to make money.
I'd say everybody's situation's a bit different.
I think it's being a little bit one-dimensional.
Yeah.
I mean, you may be in the world of one size fits all,
Yeah, well, I mean, big picture, Sam, anybody who, we've helped people do interfilings so far, we've helped people do second adjustment of status so far, and anytime we do one of those, we talk to them and help them. I've had more conversations like that than I can count to help them make a decision and tell them the pros and cons, and basically, you know, it's really a personal decision for you, because not one we make. We're attorneys, we're advisors, but it's, do you think the USCIS will get to your interfiling request faster, or a whole new adjustment of status case? And it's kind of a sad thought, Sam, that we're not sure on that, you know?
You know, everybody filed for a downgrade, and everybody filed for an EB3, right?
Yeah.
And now the government telling you, go and jump back again on the other horse,
Yeah.
right?
Yeah.
Who's to say that they're going to say, wait a minute, we have too many interfiling now, and now we have more EB3s and not enough EB2s.
Yeah, and well, the most important thing about that, Sam, is you can't withdraw that interfiling request. Once that interfiling request has been made, you can't undo it.
You cannot go back without filing another I-485.
Yeah.
Yeah.
And so I guess the big appeal of having two adjustment of status is pending is basically, you can just sit there and wait. It's whichever one they're able to approve first will be approved. And that's, again, I'm a high anxiety sort of guy. If I were in this situation, I would, me personally, it's really my personal brain workings, I would be feeling really good with having two pending adjustment statuses, because I know there's nothing more I can do, you know?
Yeah, I agree. So we have this little chart, right, Brian?
Yes, this is a chart we've shown before, and I think that the question is Sam, has our mathematics on interfiling versus a second adjustment status, have they changed? And
all right.
I have chosen the. There we are.
Need to go on.
There it is.
Yes.
So interfiling versus adjustment of status, which wins on what issue? Now.
So we said cost, interfiling wins.
Yeah, nothing changes there.
Yes. Notice, second adjustment wins.
Yep.
Clearly, there's no question about that.
Yeah.
Discretion, we certainly go with the adjustment. There's a lot more.
There's another layer of discretion built into the interfiling process. Adjustment of status is discretionary, meaning they don't have to, you know. Well, I'll spare you that explanation.
There's many years of body of law regarding that limitation of that discretion. Looks like the interfiling discretion is almost absolute. It's completely like, if we feel like we're not ready to go forward, we're going to go ahead and file for reject that. And if we were too far, so there's a lot more wiggle room for them. Although they do like it, and I can tell you that from an experience standpoint, we don't see a lot of problem with interfiling.
Yeah. Well, you know, Sam, that's a matter of timing, and we'll get into how long it will take. So next one is, I was just getting into the peace of mind. Yes. Like, if you feel good about having cases you can track, processes you can track, second adjustment of status, that still wins out.
Yeah. Protection.
You know, 2 green cards in process, meaning 2 independent means.
245s.
Yeah, of staying inside the United States.
And 2 EADs.
Yeah.
Filing flexibility, clearly interfiling gets the heads up on that.
Because you don't have to be in status to submit an interfiling request, or you have to be in valid non-immigrant status, such as H-1B, for example, to file that second adjustment of status.
Yes. Speed.
Speed. That is the question, Sam. That is what every...
To speed or not to speed?
what every call today, what every email today, not everyone, but most of them have been about.
Which is faster.
Which is faster.
I have to say, if you have... it depends.
Yeah, so I have there's a gentleman who I talked to today, and we filed an interfiling request for him, a perfectly fine interfiling request for him back in August, and absolute crickets from USCIS, you know, and that's 5 months, and I ponder whether or not they can do any faster than they have. It seems like they're trying to get organized. They have a new process with a new address to send it to. Maybe, again, a single spot where they take all these in to perhaps get organized, right? But do you trust USCIS with an untrackable process where they don't get money, they don't get a form for it to act faster?
But which one is faster?
I would say, I think...
It depends.
Yeah.
So if you have a pending adjustment status for a long time, and the priority date is solidly current for you, meaning that not like by a week, I would say you're good. if you have an adjustment that is not progressed that much and the priority date moved a little too quick and then there's a long processing time,
Yeah.
I'd say a second adjustment.
Yeah, I mean, the way I'm viewing it is if your EB3 date, if you filed back an EB3 with a downgrade back in October 2020 and your EB3 priority date is no longer current, you got to start thinking about perhaps interfiling. But if your EB3 priority date is current, meaning and your I-140 is approved, meaning they could approve your EB3 adjustment at any time, it begs the question whether you want to jump out of that line into the one that, frankly, a lot of other people are about to be jumping into.
Yes. Now, there is one column here, one row that I would like to add
To our chart?
to our chart called flexibility.
Flexibility, okay.
Because of the 180-day advantage. So with interfiling, you lose the 180 days. The moment you interfile, you cannot change employment for 180 days.
Mm-hmm.
Whereas if you file a second adjustment, you don't lose the 180-day flexibility. You can move to a new employer and file a supplement J and move on with the first first adjustment.
Based upon the original adjustment.
Yes.
Yeah.
So that's called flexibility to me, and that's, I think, worth considering.
Yeah.
Okay, so policy analysis.
Yeah.
Just
So
break it down. That's a good topic, Brian.
Yeah. So is interfiling faster now? Maybe.
Probably.
Yeah.
Speed.
Is it faster than it was? I believe so. I believe it is. That's a good point. I believe it is faster than it was,
Yes.
Sam. They're
Yes.
trying to get organized, and I like that.
Yes.
Yeah.
So we get few questions that people ask us. One of them is, can I interfile transfer basis after I already filed a second adjustment of status in the EB2? Okay?
Yeah.
Now, why would you interfile when you file the second adjustment of status?
Because
Give me a scenario.
well, let's say you just filed a second adjustment of status, 2 weeks ago, and that process is at the beginning of the processing time. The quota processing time for an I-45 is somewhere between 10 and 24 months, depending upon where it's at. And meanwhile, you have an EB3 process that is, 15 or so months into it. It seems possible that USCIS with an interfiling request could take that long processing time on the EB3 adjustment of status, move it to the EB2 category, approve that.
Another issue that we haven't touched on, Brian, is that you can file a second adjustment of status based on dates for filing.
Yeah.
So dates for filing, so your final action date is not reached, date for filing is reached, you can file a second adjustment status and lock that second adjustment. Now, then you have the final action date becomes current, then you can transfer. You can do a tub on the first EB3 to an EB2 with an interfiling. And that puts two cases in the adjustment of status, EB2 adjustment status category, which is not a big deal.
Well,
so it can be done.
Yeah, but the downside is you abandon that EB3 category. And my nightmare scenario is, if suddenly there's a big rush in the EB3 category, into the EB2 category, suddenly the EB3 dates start moving again, because that's what, the EB3 dates were ahead for a long time.
Yes.
And we basically saw EB3 go ahead, now EB2's ahead. We're out of the visa bulletin prediction business, Sam. So
yes.
You don't know what's going to happen there.
So then the next question that we get is, should I interfile if my final action date is current in the EB3? Should I interfile into EB2 if my EB3 final action date is current?
So we were just talking about this one, right before we got on here, and my gut instinct is no, because if your final action date is current and you have an I-140 approved and your adjustment of status, they can approve it at any time, and you're just basically throwing a wrench into the works of that.
But if USCIS is saying that you're oversubscribed,
yeah, so that's the thing. We haven't seen movement on the EB3 visa bulletin for months now, and everything we're seeing is suggesting that we have too many EB3 cases, not enough EB2 cases.
and with everybody interfiling to EB2, is that going to push you ahead in EB3?
These are the questions which we don't have the answer.
We don't have an answer to these questions. Those are different. If you are current in EB3 final action date, it would be crazy to interfile, in my opinion. But if you're a gambler,
Yeah. So this is why, if anybody's out there saying, oh, you must interfile to EB2 now, it's it's not such a simple answer, and it doesn't apply to everybody. It's
Yes.
What is your level of comfort?
Yes.
Understand everything that's going on there before
Yes.
you make a
Yes.
you make a decision.
Yes. So that's that, Brian. Anything else on interfiling we want to talk about?
No, but I bet we have a absolute ton of really interesting questions related to interfiling.
Uh-huh.
And I would say I'm going to push this button here, and we'll be back in a minute, and we'll talk about them.
Perfect.
Well, we're back, and we have some questions. I'm going to start. Well, Sam, you have a couple of ones. You've been
Yes.
looking at?
So yes, we're setting up the questions here on the screen, but we do have a question from Vinshu. I have a pending downgrade with prior employer, but approved EB2 with the same employer. Can I interfile? That's a tough question. The adjustment status can be threatened if you leave the EB3 employer. So that's something that we want to break down. Is that question on the screen, Brian?
No.
Oh.
Yeah.
Okay.
Yeah, I'm able to produce another one here right quick, though.
Okay.
Got one right here for us.
Rahul Roy question?
No, I have one from MP. So the I-140 is approved in both EB2 and EB3. Downgrade, let me zoom in so I can see that. Downgraded to EB3, data's current in the EB2 and not in EB3. Can we interfile on our own? What all documents are needed?
Okay.
So, well, really the question is, data's current, first of all, must be final action date current in EB2 in order to do it. And can we interfile on your own? Sam, can you interfile on your own?
Well, 100% yes.
Yes.
You can file. I mean, it's your application. You do not need the employer to be involved. That's your application.
Well, if you
you're
want
filing.
If you want to have a supplement J, though, you're going to need that from your employer.
Well, two things I'd say to that. Supplement J is recommended, not required.
Yeah, that's
to
true.
interfile. So that's the first thing. Secondly, you need the employer to sign off on the supplement J. But if you just assume that you're not able to reach the employer, they're traveling, they're a person with authority, then you can certainly throw in the supplement, the interfile, and deal with it later.
Yeah. Okay then. I'm going to keep on going. Do you have any more from us from the?
Yes. So I have. Do you have? Let's see what you got here on the screen.
I got from Rakesh S. Coming on up.
Okay.
So if my derivative used EAD/AP, am I still eligible to do an interfiling? Any difference in derivative using EAD/AP? So interfiling, Rakesh, is going to be available to you regardless as to whether or not any of your derivatives has used that EAD or AP. Would you agree, Sam?
I do agree.
Yeah. So that's that.
Yep.
I have one from Manoj K here. So here it is. Under the new USCIS guidance, if I submit the interfile application from EB3 to EB2 when the final action date is current in EB2, will my child's age continue to be locked in EB2?
An excellent question. So I think the simple way to analyze this as we're talking is to ask yourself is whether or not your child is under or above 21 today.
Yeah.
If your child is under 21 today, you're going to be okay because the interfiling is filing under final action date, so it locks the date automatically.
Yeah.
If you have a child who's now crossed into 21,
that's when I start putting out my alarms, talk to somebody who can give you a good analysis on
and
it.
you're already locked in the EB3,
Yeah.
and now you're interfiling, you could be unlocking that.
Yeah.
And that could be a problem.
Yeah.
Potentially, yes.
Yes. Going to keep on going here with a question from PS. Move on up here. So if I work remotely, work from home, and the current LCA has both home and client's address on file, do I need to apply for an amendment when I change the client, but it's still a remote work from home opportunity? Excellent question. So the only, USCIS requires an H-1B amendment. This is an H-1B question, everybody. USCIS requires an H-1B amendment. The only time they've definitively said that for sure you require an H-1B amendment is when you have a change in MSAs for your work site. However, the general policy is that anytime there's a material change, you are required to file an H-1B amendment. So it's not just the fact that the client has changed. It's really whether there has been a major change in the nature of your work. And that's the sort of conversation you have with your employer, you have with your attorney, and they can give you an opinion. Now, what drives me crazy about this, Sam, is the fact that you don't know whether you've made the wrong choice until somebody tells you.
That's very unfortunate. Yes.
Yeah. And who's going to tell you? It's either going to be the consulate at your next stamping trip. They can say, "Oh, it turns out you should have amended," and they'll give you a 221G. Or worse, USCIS in your next extension application.
Yes.
Yeah.
Indeed, yes, absolutely. That's a good question.
So let's keep it going here. A question from Yes Ven. Do you want to take this one, Sam?
Sure. I was working on H4 EAD, and my H4 EAD is expired and lost my job. I'm sorry to hear that. I applied for my H4 EAD extension, and it's pending for 6 months at the Vermont Service Center.
Doesn't surprise me, but I think there's a little bit of follow-up here.
Yeah. So what's the follow-up question?
I want to travel to India to visit my parents. What happens if I stay there? If I travel and stay there for 4 months?
Okay, so as far as the EAD, it continues. There's no issues.
However, it is possible to get an RFE on that to determine your continuing eligibility for H4 status and thereby the H4 EAD. That has occasionally come up.
Right. But usually, the extension that can.
Yeah, that survives your travel.
Yeah.
I mean, 4 months is a challenge in that. I mean, if there's an RFE,
if you have an attorney with you.
Yeah, there's some advocacy to be done there by an attorney in that theoretical RFE for sure.
So I mean, if you're doing it on your own, yes, it would be very risky. But if you have an attorney working with you that can take care of it, you'll be fine.
Yeah. Okay. Let's see what we got next. So priority date December 2013. Do we expect EB2 dates to move forward to my priority date in the next month or so? So we have our copies of the visa bulletins.
Pretty close.
So we are EB2 final action dates on January 2013, and dates for filing are at September 13.
It's close. I mean, it's possible.
Yeah, I mean, the former head of the Department of State, the former numbers guru, Charles Oppenheim, said expect aggressive movement in the first couple months of fiscal year 2022, and that's what we've seen. There may be a little bit of juice left in that. However, in my notes here, I do have, it seems that EB2 has sort of slowed down in its movement of the final action, the dates for filing.
Well, also keep in mind the new release about the oversubscribed numbers in the EB3.
Could slow down.
So we have a kind of a confirmation from USCIS from a different source, which is the Interfiling comments that, hey, we have a lot of openings in EB2, we have crowdness in the EB3, so to me, it may not move.
Yeah. You're right. The visa bulletin movement means give us cases, and this also says give us cases. This other policy, yeah.
Yes.
Okay. So this is a question from
my successor in interest from RAM. My successor in interest, EB2 to EB3 I140. E2 EB3 I140 is pending. Employment second preference. I can't figure that out.
I think it's my successor in interest. Let's going to call it an EB3 I140 is pending. Can we interfile with an approved EB2 from a different employer?
So your successor of interest is pending. It's still approved. So the I140 is still approved. Is not denied. Can you interfile? I think you can.
You have a good basis under your existing I-140, and under your existing. Yeah, I guess what it doesn't say here is that there's a pending adjustment of status here. That's the kind of missing component of a interfiling question. But we're presuming there's an adjustment of status based upon the EB3 I-140 that's a successor
with
interest.
a different employer. Obviously, there has to be a job offer. They have to be willing to, and you have an approved I-140. I don't see a problem.
Yeah, I mean that's the other. You're right. The other question that struck out with me is you have to have a job offer from that EB2 employer, a good I-140 out there from them. Yeah.
Yes.
Let's see what else we got from a frequent viewer, Sweet Seller. Why can't USCIS move EB3 dates instead of asking people to interfile?
Because they're governed by certain numerical limitations in the law, that they cannot expand the EB3, but they have availability in the EB2.
Yeah.
That's really the answer to that question. Yeah.
Here we are from Jitendra Valecha. So I downgraded to EB3 in October 2020 and received my EAD. My priority date is in May 2014, but my spouse has an approved I-140 from a previous EB2 employer with priority date can I use priority date July 2013? Can I use her priority date for my interfiling?
Well, she has an adjustment of status.
Yeah.
So she can definitely transfer her underlying basis from his derivative to herself, and then he can become a derivative.
Yes, but yeah, you can interfile from go from being a primary to a derivative and vice versa. However, you can't use her priority date on your for your I-140 and get that priority date.
It can be done, but a little bit different than what you're thinking. Obviously, it's the kind of thing you want to consult with a lawyer, but it can be done. Yes.
Yes. Let's go for it, Sam.
All right, my priority date is April 2013, and I filed my I-485 and EB3 in October 2020, and then refiled the 485 again in EB2. So you have two 485 this month. Can I interfile my old EB3 485 to EB2? What's the pros and cons? Excellent question. The answer is yes, you can. The pros and cons. Pro, obviously, you've moved a older adjustment into a more available visa category, which is the EB2.
Yeah.
The downside is you've abandoned the EB3 track.
Yeah, I mean, the final action dates for EB3 are now presently 15th of January 2012, so obviously your priority date is quite a bit away from current in EB3, so it becomes really attractive to interfile the category. Yeah.
So clearly, yes, absolutely.
Yeah.
It can be done.
There's from Sweet Seller. So it's, can a dependent child continue on H4 beyond 21 years if the child gets extra time due to time gained from a pending I-140?
I wish.
So, well, they don't get time on H4 status, but basically the pending adjustment of status can keep them in the United States, right?
Yeah, so obviously they are no longer on H4, but they can definitely continue staying in the United States.
Yeah, so long as
the adjustment status is pending.
Yeah, so long as you have a pending adjustment of status, that child can stay beyond 21 years. They just, again, wouldn't be on H4 status. Keep on going here.
My EB3 I-140 downgrade is still pending, and my priority date is February 2014. When my EB2 date becomes current, can I interfile with my approved EB2 to EB3 I-45 through my EB3 I-140, though my EB3 I-140 is pending? The answer is yes, but let's go break this down so everybody understands. So EB3 I-140 downgrade is pending, priority date 2014. So when the EB2 becomes current, not now, because the EB2 is not current for that date, can I interfile? The answer is yes, absolutely.
Yeah. The big underlying requirement is that you have to have a visa immediately available in the new category. That means final action dates must be current. It means they have a visa available for you if only you were in that category.
Absolutely.
Yeah.
Good point, Brian.
Okay. Here we are, going to keep on going. So from Siddharth Somani, my EB2 priority is May 2013. Parallel downgraded last year and waiting for I-140 approval along with a concurrently filed 485. Can I still go ahead and interfile for I-45 in the EB2 category now? So parallel downgraded. Well, downgraded. Downgraded is a kind of a loaded term, Sam. You know. We should talk about this. Some folks have, when it came to back in October 2020, when filing that second I-140 in the EB3 category, some people had their cases amended, basically modifying the existing EB2 I-140 approval and turning it into an EB3 I-140 approval. And some would have had their cases, a second I-140, a second fresh I-140 in the EB3 category. So that's one thing I think about when I read this question.
So if the I-140 is not amended and it was simply a filing of a new I-140 in which the original I-140 remained valid, you can certainly do that.
Yes.
If you have filed an amended I-140 in which you have changed the category, not filed a new I-140, there's a little box. You have to check whether it's a new or amended. and a lot of people were doing amended because they were worried about USCIS denying the cases, because obviously the prior administration was so generous and nice to give us a lot of details and instructions on how to do these things. They kind of left us in the dark. So yes, if you are new I-140, yes. If amended I-140, no.
There we are. So next question from Mohan Vermani.
What do you think about USCIS's message? Alert, there are exceptionally high number of employment-based visa available. Yes, what do I think? I think it's, well, I think in many different levels about it. Number one, I do like the proactiveness of this administration to what we've had before. I do like the fact that they're trying. We didn't have that in the last administration. So I like that. Is this a great way to communicate? No. But you know what? I'll take it, man. If this is, it's
better than nothing.
More positive than negative, trust me. I mean,
Yeah.
70% positive, 30% critical. That's the way I feel about it.
So
All right, next one.
When I think about that, Sam, I worry about, the next year, honestly. I worry about the next fiscal year. And our presentation last week was really about the numbers and how productive the Department of State is being at the consulate. And, the whole big visa availability this year is attributable to the fact that the Department of State wasn't issuing many visas last year. And we looked at the numbers for the most recent fiscal year, and it seems like they're on track to mostly be fully operational.
They're like 90%.
Yeah, 90%. So that makes us worry about, it makes me say, let's get those green cards approved this year, because we're not so sure that
We're going to
next
get
year.
a lot of flow over,
Yeah.
or overflow.
Yeah. Here we are from Pakala Prasad.
Okay, my daughter got protected under the Child Status Protection Act and is now 22 on green card EAD. What happened in September 2023 when her EAD renewal comes up? If she doesn't get approved with the additional 180 days, she still stays in adjustment status? Question mark. So I'm not sure about the injection of the 180 days.
I think I understand the question.
If she doesn't get approved within the additional 180 days.
So I think what Pakala Prasad is talking about is the automatic extension of green card EADs for 180 days when you file timely. And I think we must correct your presumption that your daughter's adjustment of status is the validity of her stay in the United States is not tied to that green card EAD. It's tied to the pendency of that I-45. What authorizes her to stay in the United States is that I-45 approval notice. Receipt notice.
What she needs to be careful about is when the EAD number one, we may be in an EAD premium processing this year anyways, and that may resolve your problem. Number two, it's very critical that your daughter stops working the day the EAD expires and pick up working again when the EAD and the 180-day extension runs out if she does not get it approved, and not accrue any violation of her status, because obviously there is a limitation on violating your status, 180-day limitation. So just follow the rules. And hopefully with the EAD premium processing coming this year, she will not have a problem. But congratulations on the locking of the date. That's wonderful news.
Yeah, it's a good thing. So here's a question from VNY. So isn't it true that since a second AOS requires a new I-140 and a concurrent filing of adjustment of status, AOS will take longer than interfiling? Well, it doesn't require a new I-140. Your I-140, if you already have an I-140 approved in the EB2 category out there, that I-140 is, it's still out there and available to you as long as your employer is willing to support it.
Yes, but it can take longer if you are going through the whole span of the 10 months of adjustment status processing, processing time for a normal I-45. It does take longer. The question, when an adjustment status is more attractive than an interfiling, is when you don't want to abandon the EB3 because you're close, but also the EB2 is getting close and you have to make a decision, so you kind of hedge. Or you're looking at potential changing employment, and interfiling resets the 180 days, and now you have to wait 180 days before you can change employers. That's another situation in which adjustment status can be more attractive. So it's not for everybody, and it's not something that we're advocating, but it is not the world is not two-dimensional, the world is three-dimensional. So you have to look at every case in depth, a little bit of depth, and not say, oh, I will never do adjustment status for anything. That's not very helpful.
Yeah.
So you got to look at every case. In some cases, adjustment status is absolutely the right thing to do. In other cases, interfiling is absolutely the right thing to do. And the last thing is, it's your preference and your comfort level once you look at the pros and cons and decide which way to go.
Question from RRH. What's the point on requesting more EB2 applications if the large number of pending ones are not being processed in a timely manner? Hey, great question.
No kidding, right? Approve them before I can interfile.
Yes, I agree. That's my answer to that comment.
Yeah.
I mean, that's why we're talking here. Is there really a surefire solution that says that's the fastest way to your green card? These are the questions we have.
I circle back to the gentleman that brought the question. What do you think about USCIS's comment? Alert.
Yeah.
Alert what? There's 1 million green card applications pending you're not touching. Why are you alerting anybody?
Yeah.
Yeah, good point.
It's funny. It seems, why are they soliciting more work for themselves? I mean, maybe maybe internally they've had some shouting at themselves about, we let how many green cards slip through our fingers that year. That is not the goal of our agency, and maybe that's a matter of the change of administration.
Yes.
Maybe it's somebody out there. They have a director now. Maybe that's them trying to get their act together.
Yes.
So, Sam,
All right.
Does interfile with the same employer with existing EB3 I140 reset the 180-day clock?
Yes.
Interfiling resets the clock. Easy
Yes.
answer, right?
Yes, you start all over again. You need 180 days to be able to use Supplement J, go to a new employer. Same employer or different employers.
So if I don't file I-45 and
Supplement J.
J interfile, does it reset the 180 days?
Yes.
Yes.
But those are great questions.
Yeah, no.
Those are great questions.
Sam, we have, especially me, we have this nasty habit of trying to pull everything apart and put it back together again and give you really detailed answers. I like ones that we can say yes to at the same time, too.
Well, here's the one that I got. Can I interfile when I'm outside the U.S.? And the answer is no.
Yeah.
You got to be in the U.S.
Yeah. So we filed under EB2 last week. Can we interfile?
Yes, in general, I need to know more about your case to see whether it makes sense.
Yeah.
But absolutely, yes, you can interfile.
Yeah,
Yeah. But the fact that you filed an adjustment status last week, I want to look closely to make sure that it really makes sense.
Yeah.
But absolutely, yes, you can.
So, a follow-up question from Rakesh S. So, if my derivative used EAD AP, am I still eligible to refile in EB2? Any difference in derivative using EAD and AP? So, the way I understand this question, Rakesh, is basically if your derivatives have dropped out of status, can they file adjustment of status again?
Okay, so you either, yes, well, not dropped out of state, yeah, but did not, but that doesn't mean they violated their
They're
status.
still legally present in the United States, but they chose to use that green card EAD AP, which means they're not in H4, L2, E2, whatever their status is in the United States anymore.
Are you eligible to refile in EB2? Now, refile, I'm assuming filing a new adjustment status in EB2, and the answer is yes for you.
If you're maintaining your status,
that
kind of presumes only derivative, yeah.
But not for your derivatives, at least until they get back to H4, if you're maintaining your H1B.
Yeah, which up until very recently, Sam, this was a big problem. Can your family ever get back on H4 status if they took advantage of those green card EADs, for example? Yeah. With stamping actually being available now. Thanks, consulates. It's a better situation on that front.
You can definitely get stamped and then file for adjustments. And don't do this without an attorney's help if you have to do it on your own, because there's some strategies involved to make sure everybody adjusts at the same time.
Yeah.
All right. My H4 and H4 EAD is still processing. What happens if I travel out of the country? I'm planning to come to U.S. after 4 months. Will it impact my application?
I remember this question. We answered Fen's question. This exact issue earlier.
Yes. I mean, obviously, I'm assuming Not only the H4E, the H4E. Okay, so we just answered it.
Yeah. Yeah.
wanna-
They can issue an RFE on that subject. You know, Sam, I got to make a comment. We're so close to 1,000 subscribers.
Okay.
I want to get to 1,000. That's all.
Oh, well, I'm sure we will get it.
Yeah.
Please subscribe if you thought like this show, and we appreciate it.
Yeah. Sometimes I can't resist asking. It's been a while since I've asked.
Absolutely.
Yeah.
We love more subscribers.
It makes me feel good when I get a little ping on my phone saying that Mr. or Mrs. So and so has subscribed.
Okay, yes, it
Yeah.
does. Yes, absolutely.
So
What do you think about the message from USA? There are many more visas available in the first and second employment base than pending adjustment status application. Yeah. Well, I mean, what do I think about it? I think we've answered that question.
yeah, I think it's just another a repeat
Yeah,
there. So let's
yeah.
see what else we got. If my dates are current in both
I.e. downgrade EB3 and also EB2.
yeah.
What shall I do?
Yeah, will you suggest to interfile? If you're current in both categories,
Well, I mean, if you're current in both categories and your case is in the EB3, that's the dilemma, right?
well, yeah, but I mean, how old is this EB3 case? Is my question. You know, if your EB3 case is, if you're just about to file, you know, right now, I'd say, well, heck, throw one out in both categories and let them fight it out. You know?
Right. So how long is your EB3 adjustment is pending? Is that your question?
Yeah, that's really what I think
Yeah,
about.
if it's very fresh, absolutely throw another one in.
Yeah.
If it's been there for like a year or so, what do you do?
Well, so in that scenario, if your EB3 has been current for a year and your assuming your underlying I-140 is approved as well.
Not current for a year.
Oh, sorry.
EB3 has been pending.
Your EB3 has been pending for a year.
Adjustment status has been filed. A year, it's been going on for a year, but they don't touch it until it's current,
Yeah.
right?
Yeah.
So if it's current like this month for the first time, what do you do?
If it's current this month,
Or maybe 3 months, 4 months.
I'm hesitant to touch that to do an interfiling request on that EB3 case because you know you're moving into the EB2 category and they're saying you know there's plenty of visas available in the EB2 category, so it's very tempting, right? But you're current in the EB3 category; they can pick up your case hit anytime.
Yes.
And you're adding another wrench to the works, right?
I would say that. I would like to look at dates and look at them carefully to give you a better answer.
That's my Yes.
Yes.
I will take that. That's a very
Yes.
good asterisk on my answer, which I
Yes.
appreciate. So with the USCIS interfiling announcement, can we safely assume that EB2 will not retrogress in the next few months?
You can safely assume that if the government they know what they're talking about and consistent. But you cannot, because we do not know the number of interfiling that we're going to get for the next 2 months.
Yeah, and
because we get a zillion of them, they will retrogress.
Yeah, and one of the last things that Charlie said in his farewell address to Ayla was, you know, hey, it's a distinct possibility that we could see some retrogression in EB2 before it moves forward, before we move it further again later in the year. So I put retrogression fully possible on the table.
Especially with this note and everybody now jumping on the EB2.
Yeah.
This is nuts.
Yeah.
What is this?
It's the U.S. government's immigration system.
It's crazy. I mean, I have no idea. All right.
So here's a question from Fenindra. My priority date is March 2012, which is current in EB2 in December 2020, and downgraded in EB3 and use the EAD. And so
can I interfile EB2 as per the alert, or should I be on H1B as I am with the same employer? Well, you should always be on H1B if you can. And I know there are different opinions out there. And again, the world is not two-dimensional. The world is three-dimensional, so you have to look deeper a little bit and not look at the surface.
Yeah.
And so you should try to stay on H1B. Now, so maybe interfiling is going to cause him to go with a different employer that is willing to take him without an H1B.
Yeah.
That looks like from the question.
Yeah.
Probably 2012 in EB2.
Which
So final action date in EB2 is 2013 right now.
Yeah, so he's, yeah.
So it's good, and EB3 is 2012, December to January. Yeah, I'd say interfiling is attractive in this case.
Yeah.
Now,
you have
can
a long.
can
You have a, the bottom line is you have a long pending case, and
Yeah.
and you can take that to the category where
do
they
you
could actually
abandon
approve
the
you.
H-1B to interfile?
So
That's not the question he wanted to ask, but that's the question
Well,
I want to ask.
Sam and Brian of last week kind of delved into this issue, and and how many employment-based adjustment of statuses do they really deny? It's not that many. It is entirely.
It's like a 1% or less than that.
Yeah, I mean, we basically, it's a very small amount, and basically, people. I guess most people who have a problem know they have a problem.
Yeah.
So
that's that.
There's that.
Yeah.
It's a personal decision for you to decide whether you're going to abandon your H-1B status, and for some people it's impossible to maintain H-1B status, and they do fine. They get their green cards in the end. You don't have a crystal ball on that front. But yeah.
Yep.
Going to keep it going here. So.
Please, does it mean that biometrics is applied to my case? Does it mean fingerprint completed?
So we missed. I think there may have been a first half of this question. I think maybe it's just talking about one of those status messages you get from USCIS when you track the case. Maybe it came in the wrong order. Nope, I'm not seeing it there. So I'll talk a little bit about those notices you see when you track a case at the USCIS. I'd say they're not really super accurate, and don't read too much into them. When biometrics is applied to your case, here's how I know biometrics is applied to your case. You either go in for biometrics, or you get one of those notices that says, "Hey, we had your biometrics on file. You don't need to come in for biometrics." Yeah.
Good summary.
Sam, go for it, sir.
All right. So my EB3 downgrade I-140 is approved on prior date 2011 in Nebraska. Should I have to interfile back to EB2 or wait in EB3?
Ooh,
Okay,
your priority date is
2011 in EB3. Final action date right now is 2012.
Yeah, and your is what in 2011? It's October 2011. I mean, that's 5 months current in EB3.
Yeah,
and
I would not interfile.
Yeah, it's tempting.
No, it's not even tempting.
I can see how it'd be tempting. Sam, I'm going to use a metaphor. It's like you see a pie on a countertop, right?
Yeah.
But you're not looking at the pie that's right in front of you.
What do you do here?
I am inclined to. So the only thing, there's nothing stopping them from approving his green card right now, right? Aside from some.
So on the let's break it differently. The argument for interfiling is one. It's discretionary, and if they're too far deep into approving him in the EB3, they can just say, "Hey, here's your green card. Forget about interfiling." So there's that potential.
Yeah, that's a good point.
And so that's the argument for interfiling is that they could just, if they are about to approve you, they can continue processing it.
Yeah.
And if they're not, and your case is dormant, and now you jump because obviously EB2 is 2013, it puts you even, more into the current dates, then most certainly it makes sense. So the argument for it is strong. It just makes me nervous.
Yeah. I mean,
Consider the 180 days. Is the 180-day reset of the clock a concern for you? If your job's solid and you don't have to transfer, then maybe you can do it. Go for it.
So, Sam, we're starting to come to the end of our time, and we have plenty of questions left. I figure I'm going to just maybe spin the wheel a little bit and answer some that just go down the list a little bit.
Why doesn't USCIS look at pending adjustment status EB2 as one bucket and process all that is pending rather than make folks jump through loops and create overall delay in the system? Because they don't have a smart people like you helping them make decisions, Censor. Because the law is written without any understanding of the reality of what goes on the ground. But you're absolutely right.
Yeah. Well, let's see here. I'm going to come up with some...
Let's go for it. Yep.
Yep.
Brian?
Here we are. Can you share your views on I-765 premium processing for AOS applicants or non-immigrant applicants? When can it be available?
This year.
We had that was on our end of 2021 list of what to expect in 2022.
Yes.
We know there's a regulation out there. It hasn't been published yet, but we are expecting it this year.
Yes.
Yes, I like that. Thumbs up.
A lot of money, but yes, we like it. It solves a big problem for a lot.
I don't
of
like
people.
the money.
It's
part
ridiculous.
of it.
Yeah. Well, with that, we end our presentation today. Thank you guys for listening to us, and like Brian said, throw him a bell or a subscription. He will be very appreciative.
I
You guys have a
like
great day.
comments too, Sam. I like comments.
comments as well.
too. We respond.